Great. Well, thank you so much. And thanks to everybody who's joining this first panel in the early afternoon. You really are in for a treat because we have assembled for you the all-stars of Fourth Amendment and privacy, talking to you about surveillance and technology and the way that they intersect with our Fourth Amendment rights and whether we need additional statutory rights. We will hear both theoretical and empirically grounded approaches from both the world of academia and the frontiers of practice. So before I introduce our three panelists, I want to remind everybody that during the session, you have the ability to submit questions to our panelists. You should be using the Q&A function on the bottom of the screen rather than the chat. So by way of introduction, first we have Jennifer Lynch, who is the Surveillance Litigation Director for the Electronic Frontier Foundation. She leads the organization's legal work challenging government use and abuse of search and seizure technologies through the courts. She founded EFF's street level surveillance project, which informs advocates, defense attorneys, and decision makers about new police tools. Welcome, Jennifer. We also have Jamil Jaffer, who is an assistant professor of law at George Mason University, the Antonin Scalia Law School, where he's also the founder and executive director of the National Security Institute and the director of the National the National Security Law and Policy Program. He teaches classes on counterterrorism, intelligence, surveillance, cybersecurity, and other national security matters. He also serves as vice president for strategy, partnership, and corporate development at Arnett Cybersecurity, which is a startup technology firm founded by former NSA Director General Alexander. Welcome, Jamil. And lastly, we have Professor Chaz Arnett, who is an associate professor of law at the University of Maryland, Francis King Carey School of Law. His research interests rest at the intersection of race, surveillance, and technology. Before teaching, he served as a trial attorney with public defender offices in Baltimore and New Orleans, and as a staff attorney with the Advancement Project. Welcome, Chaz. So thank you all so much, and we're going to start with opening remarks from Jennifer Lynch.
Thank you, Professor Levine, and thank you to the organizers for inviting me to this fantastic symposium. The earlier presentations have been thought-provoking, and I'm really looking forward to our discussion on this panel. So I'm here to talk about technology and the Fourth Amendment and what we're seeing in litigation and criminal cases on the ground sort of day to day. I think it comes as not a surprise to anyone that technology is becoming exponentially more sophisticated. This affects our lives and criminal investigations in a few different ways. I'll talk about what I see as the 6 big ones. First, we all individually rely on more and more technology in our day-to-day lives, and it really permeates everything. Most of us have multiple devices, phones, watches, IoT technology. In fact, most of us live in households with at least 5 to 6 devices. And many activities that we used to do in the analog world in ways that couldn't easily be tracked and recorded, we now do digitally, like shopping, reading the newspaper, dating, talking to friends and family, turning our lights on. Maybe some of you watching can't even imagine a time when the only way to do these things was to physically go to a store, buy a printed paper, or pick up a landline phone. But now we're doing all these things and so many more in ways that leave digital trails. Second, technology is cheaper. It was a big deal in 2003 when we sequenced the human genome, and that was in my adult lifetime. It required the collaboration of many countries, took 13 years, and cost about $3 billion. Now, you can have the most important parts of your DNA sequenced by a private company for under $100. You don't have to go to a doctor or a lab. You can collect your DNA at home, and for free, you can compare your own genetic data with others to find long-lost relatives and identify genetic traits. And you can do all of this just as long as you're willing to give your most personal data to private companies. Third, we're all generating more data. The storage capacity of the average smartphone today is 5 times as large as when the Supreme Court decided Riley just over 6 years ago. The average smartphone user has 60 to 90 apps on their device and uses about 30 different ones over the course of a month. The data on or generated just by your phone can include call logs, emails, text messages, browsing history, calendar entries, contact lists, shopping lists, notes, photos and videos, books read, TV shows and movies watched, financial data, sleep patterns, heart rate, menstrual cycles, health information, purchase history, dating profiles, metadata, and so much more. On top of that, we consciously share information about ourselves online in public and semi-private forums. And we use technology like some of those apps on your phone that collects and shares information about us without our even realizing it. Fourth, sophisticated algorithms make it possible for even small bits of aggregated data to reveal patterns and details of our lives. For example, data on where you've been in the past, when it's aggregated over time, can reveal not just whether you were at a specific location at a specific time, but also your political affiliations, religious beliefs and practices, sexual and romantic life, financial status, health conditions, and family and professional associations. Fifth, police technology is also getting cheaper and more sophisticated, and the police are collecting and have access to more and more of our data. For example, most police departments have automated license plate reader systems with cameras on top of squad cars that scan tens of thousands of license plates every day. That data, along with where and when the plate was recorded, goes into regional and national databases to be shared with federal, state, and local law enforcement across the country. Also, most police departments have access now to mobile forensic technology that makes it possible to download the data from almost any phone. And face recognition systems are being used to identify and misidentify people in even very low-level criminal investigations like shoplifting. Finally, technology and aggregated data today allow the police to essentially pluck a suspect out of thin air. Through geofence warrants and location data that Google collects from apps and Android devices, police are able to figure out almost everyone who is in a given area during a given time period. Through searches of genetic genealogy databases, the police can use DNA to track down perpetrators in decades-old cold cases. And even things like private Wi-Fi routers on a college campus can reveal who was in a given place at a given time. But the law struggles to keep up, and that's where I come in. My job is to explain the technology to courts and persuade courts in the best way to apply or not apply old Fourth Amendment case law dealing with the physical world to new technology. And that's really what I find exciting. For example, how do you explain to a court that even though we share information with a third party or make our actions visible to the public, we still have an expectation of privacy in that? There's literally decades of case law against this. Sometimes this takes a long time. In this case of historical cell site location data, we've made this argument in cases for nearly 10 years, and it was frustrating. We got some great opinions from state courts and district courts, and even some good opinions at the federal appellate level. But by 2017, we had lost this argument at all of the 5 federal courts of appeals to take up the issue, only to ultimately take home the big prize with a win at the Supreme Court in Carpenter in 2018. Now we have 3 great Supreme Court opinions on technology, Jones, Riley, and Carpenter, and I can take those opinions to lower courts and argue that the reasoning in those cases should apply to other technologies. We're currently doing that in cutting-edge cases around the country involving geofence warrants, license plate databases, DNA collected without the suspect's knowledge, consent searches of cell phones, and many other cases. So why does all of this matter? Especially for people who think they have either done nothing wrong or have nothing to hide? Well, I think there's 3 reasons. First, we all have something to hide. We each may just draw the line at a different place. But at the end of the day, and to use an extreme example, none of us want the police to have access to a 24/7 video feed from cameras inside our homes. That leads me to the second point. Our Constitution and our system of government was designed to put power ultimately in the hands of the people, not the government. If there are no checks or only weak checks on government surveillance, the government holds all the power and we no longer live in a democracy. Third, and most important, people who look like me and people who say they have nothing to hide are generally not the targets of arbitrary government surveillance. That happens disproportionately in communities of color, immigrant communities, and minority communities. It's easy to see the effects of this in our criminal justice system, where African Americans and Latinos are disproportionately represented. And I'm sure Professor Arnett will talk more on this later. So that makes it even more important for people who think they have nothing to hide to step forward, speak up, and challenge excessive government surveillance. We all need to stand up for communities who may have less of a voice and less power to push back on this surveillance. Thank you.
Thanks, and thanks to Emory and Professor Levine and everybody involved in helping us set this up and having us here today. My name is Jamil Jaffer, and I work at the National Security Institute at George Mason University, Antonin Scalia Law School. I want to talk a little bit about what Jennifer talked about, which is this idea of pervasive government surveillance and the facts of what we've actually seen in revelations about government surveillance. So I agree with Jennifer completely that we have seen an explosion in the quantity, scale, scope, speed, criticality of the information that is transmitted over our mobile devices, over the global internet and the like. It's estimated by next year alone, we'll see more data transmitted over the internet than all the data transmitted over networks up till 2018. So the amount and scope and nature of this information is massive. It's also important to note that the importance of that information, right, the nature of that information, your social security number, your credit card information, your banking information, all of that is currently in some form or another, typically encrypted, being transmitted over the global communications networks. And we know that the threat to those communications networks is significant, not just from foreign nation states that surveil our government and our private sector, as well as individuals in relevant cases, but from criminal hacker gangs and the like, who increasingly have nation state-like capabilities, and individual hackers who are looking to make money, monetary gains, or getting involved for their own purposes, ideological or otherwise. So there is a tremendous amount of information. There is a tremendous cyber threat to that information, and there's a question about the appropriate role and the appropriate scope of government activities in that space. And Jennifer's made a very strong case for the idea that when you have this tremendous amount of information being transmitted in a variety of forms, and a lot of that information now residing on these handheld mobile devices that you have, which would have previously taken up, libraries and libraries of space to house, that we might want to apply different rules. But of course, the challenge is that we don't apply different rules currently, right? The laws have changed somewhat, but they haven't changed dramatically, and the Constitution hasn't changed dramatically, right? The Fourth Amendment is what it is, right? And the Fourth Amendment is premised on a core construct that if in fact the government wants access to certain kinds of data, right, it has to go through a process, right, and it can obtain that access, right? And it's my view that the traditional rules that have always existed with respect to the Fourth Amendment, the lines that we've created, the boundaries that we've created, actually have served us very well for the better part of 200 years and need not be thrown away simply because of the change in technology, right? We didn't throw those core concepts away when we developed new technologies like the telephone. We went from an era of handwritten communications to Morse code, to the telephone, and to radio, then the telephone, to satellites, to fiber optic cables, and today to the tremendous form of communication and information that represents the global worldwide internet. And along the way, while we made certain legal changes, we enacted things like the Electronic Communications Privacy Act, the Right to Financial Privacy Act, and various other federal statutes, we didn't think a fundamental amendment of our Constitution was necessary. And the Supreme Court, while it did certainly modify its case law along the way as it saw government abuses and the like, and wanted to police the boundaries of where the Fourth Amendment protected people's rights, we originally began with a property rights conception of where your communications were protected and where the Fourth Amendment stretched. Right, we always thought it was built around the home and that list of places in the Fourth Amendment. And we've taken a more expansive view over time as technology has changed, including all the way to cats, where we threw away the sort of text of the Fourth Amendment, and the words are actually in there, in favor of what I think most people agree is an understanding of privacy that is more expansive and more protective of individual privacy, that protects the person in their communications, not necessarily where those physically take place or where they reside, and extended the Fourth Amendment in certain ways. Right, we've now seen an increasing and I think a drastic evolution and change in that in the courts, as Jennifer has correctly outlined, in the Sotomayor concurrence, or was it a dissent in Jones, a one justice opinion, but that really previewed where the court was headed on the way to Riley, and then from Riley to Carpenter's. We've seen a massive, I think Jennifer's right to describe it as a massive evolution in the doctrines around the Fourth Amendment, because of a understanding of how technology applies in space, and an understanding that perhaps we ought to expand the scope of the warrant requirement well beyond where we traditionally understood it to be, to areas where it now is today. And all of this takes place, all this evolution, while it has largely taken place in the context of domestic criminal law enforcement surveillance, also has a tremendous impact on our understanding and our authorities for national security surveillance, right? At least since the 1970s, we've had a statute, the Foreign Intelligence Surveillance Act, that has governed surveillance for national security purposes in the United States, with the exception of certain cases where surveillance is authorized otherwise by law. There's obviously the big debate that took place that we had publicly, and that took place within the government in the lead up to and then the aftermath of the Snowden revelations about government surveillance, about whether the authorization for the use of military force, as happened after 9/11, whether that created some new authority for government surveillance that went beyond what FISA provided, because it was a separate and distinct authority for government action, and whether surveillance, like detention, like the Supreme Court held Hamdi, was a necessary adjunct or necessary prerequisite to the use of military force. And so we've had a lot of debates and discussions about national security surveillance, particularly in the aftermath of Edward Snowden's revelations, where he revealed a major surveillance programs targeting the metadata of Americans here in the United States. We had previously heard, and the government had disclosed, information about collections on content. Ultimately, that resulted in statutory modifications back in Section 702 and the creation of that portion of FISA and the collection of content in the United States from American telecommunications providers, but targeting foreign actors overseas. And then even in the aftermath of the Snowden revelations, we didn't see an immediate curtailment of the activities that Edward Snowden complained about and that everyone seems so deeply concerned about. We actually had a continuation of the metadata program, albeit under significantly modified authorities passed by Congress, but fundamentally a reauthorization of that program. The program has now obviously been taken offline because the government has determined that wasn't necessary or worth going through the hassle of going through the process created by the USA Freedom Act. But certainly we've seen an evolution in both the understanding in the public arena and in the courts and in Congress about how we should think about surveillance and the like. And yet, throughout all of this, the Fourth Amendment has remained constant. And our understanding of the Fourth Amendment has remained constant, although evolving over time. But the fundamental core precepts of the Fourth Amendment, how it thinks about the role of individuals, the role of locations, and the like, has stayed fairly stable, right? And so what I want to end on is one point that sort of touches on the evolution of surveillance in national security space, and this is the debate around encryption, right? One of the core tenets, I think, of all of our collective understanding of our communications on these highly networked systems, including over the internet, turns around the ability to protect some of that very sensitive information, right? I think there's not a person on this panel who would disagree that strong encryption is critical to the protection of financial data and other personal sensitive data, right? A lot of us probably are all on Signal. A lot of us were on WhatsApp, and we're pleased that WhatsApp had implemented end-to-end encryption. And then after the recent change in their policies, a lot of people have migrated to Signal. But I think people generally support the idea that your private communications ought to be well encrypted, and particularly when you're transmitting sensitive data like financial data, your social security number and the like, albeit the fact that a lot of that data is now out there given all of the hacks that have and breaches that have happened, and the collections conducted by, in particular, the Chinese government against U.S. infrastructure has largely revealed a lot of that data, or at least foreign governments are now in possession of it. I think there's still a general agreement that strong encryption is critical to protecting the needs and desires of both Americans and our allies and freedom lovers all around the globe. And at the same time, I think there's also a understanding, and perhaps heightened after the insurrection that took place on January 6th at the Capitol. And let's be clear, that is what it was an insurrection, a rebellion against the United States government, fomented by a small but clearly passionate, motivated crowd of people, and stoked by the President of the United States from the Oval Office. One of the things we learned in the context of those events, as well as in the context of the communications that terrorists and other foreign intelligence targets engage in, is that they like to take advantage of this strong method of encryption and enjoy hiding their communications. That just a year or two ago, we heard from the director of the FBI, Chris Wray, that we were losing tremendous amounts of surveillance on Americans who were having communications with Al-Qaeda and ISIS operatives overseas, who were being recruited by them on communications media that we had access to through lawfully authorized, court-authorized, warranted surveillance, and that they were moving them to encrypted channels, wherein, even with a court order, the government had challenges getting access. And we saw the infamous fight between Apple and the FBI over the iPhone of an actual real life terrorist in San Bernardino who was actually killed in the acts. And Apple defended its ability to not provide the access to encrypted data. Well, their point was we've thrown away the key, so we don't have access to it. So, this remains an ongoing debate. And what I would say about this debate is it's a fundamentally unstable debate. The Fourth Amendment has always been premised on the idea that if the government goes through the process and gets a federal court order It has access not only to concept communications, but access into your home, into your most private possessions, into your drawers, into your diary, and has the ability to use that information in a court of law if it obtains ahead of time a warrant from a federal judge based on probable cause. The situation with strong encryption, however, and without having some method of lawful access for the government, means that the government, even with a warrant, can't access that information. And this is fundamentally unstable because while today it may look good for those who support the idea of encryption and limiting government surveillance, the reality is that the American people are fickle. We are one major terrorist attack, one significant kidnapping, one significant killing of a child away from Congress coming in, intervening, and mandating a technological solution that may not be technologically savvy, may not be as protective as necessary to protect individuals and protect potentially national security. And so what I would say is on the encryption issue, as with a lot of these other issues, the Fourth Amendment has served us well. It works well. We ought to find a path forward that both protects the importance of the privacy that we believe in and that we know is necessary, and the necessity of strong encryption for the internet. At the same time, recognize that the Fourth Amendment is premised on the idea that the government can and should have access in appropriate situations where it has obtained a federal court order from a neutral third party bench. And we've got to find that middle ground, because if we don't, the unstable situation will ultimately lead to bad results, bad legislation, bad court cases.
I like to begin with a quote. I am invisible, understand, simply because people refuse to see me. Like the bodiless heads you sometimes see in circus sideshows, it is though I have been surrounded by mirrors of hard, distorting glass. When they approach me, they see only my surroundings, themselves, or figments of their imagination. Indeed, everything and anything except me. That is a quote from Ralph Ellison's book, Invisible Man. And I want my comments here to be framed by that duality that Ellison picks up on, the notion of not truly being seen for who one is, and yet subject to perpetual watchful eyes and gaze distorted too often by deep notions related to skin color. Thus, I want to touch on the intersection between race and surveillance and how our understanding of that relationship and the ways that current strategies and technologies that are furthering racial surveillance should shape the way we think about Fourth Amendment protections, jurisprudence, and advocacy. And perhaps it may be apt for me to begin with defining racialized surveillance. When I talk about racialized surveillance, I am adopting and referring to what Simone Brown defined in her book, Dark Matters, on surveillance of Blackness. She notes that racializing surveillance is a technology of social control where surveillance practices, policies, and performances concern the production of norms pertaining to race and exercise a power to define what is in or out of place. Thus, racialized surveillance signal moments when enactments or deployment of surveillance reifies boundaries, borders, and bodies along racial lines, and where the outcome is often discriminatory treatment of those who are negatively racialized by such surveillance. So when we talk about racialized surveillance, we're talking about surveillance that is being used to legitimate and maintain racial hierarchy, either explicitly, we have seen, as we have seen historically, or implicitly through entrenched institutional practices, policies, regulations built upon white supremacy. In a recent law review article entitled Race Surveillance Resistance, I argue that racialized surveillance practices predate the founding of the country, and with that precede the drafting of the Fourth Amendment, what we've been talking a lot about, and oftentimes has little to do with public safety, but rather the maintenance of the racial status quo. In addition to laying out the long arc of racialized surveillance of Black people in this country, I highlight in this article that not only has law failed to protect some of the exalted values of liberty and freedom in terms of racial justice and privacy, but also law and law enforcement have been active conspirators in suppressing movements for racial justice and equity through facilitation and licensing of racialized surveillance practices. And in each period, I also note where law has failed to provide these protections, we've seen Black communities forge channels of resistance like the Underground Railroad during enslavement. In the article, I also wrestle with how advancing surveillance technologies are impacting how we think about racialized surveillance, be it aerial surveillance like used in Baltimore where I live, or stingrays, or social media monitoring, electronic ankle monitoring, or facial recognition software and technologies. I argue that these new technologies are impacting our attempts to limit racialized surveillance, because many of the assumptions that we hold about technology, that it is neutral, that it is passive, that it is fair, that it is efficient. Thus, we see the weaponization of the purported neutrality, independence, and progressiveness of advancing technology. This argument is used as a shield to protect against deep critiques. As Ruha Benjamin notes, you have the furtherance of anti-Blackness with the assistance of law where, quote, race-neutral technologies, purportedly race-neutral technologies, encode inequity, are linked to race-neutral laws and policies that serve as powerful tools for white supremacy. So take, for example, the aerial surveillance program, pilot program in Baltimore that just ended at the end of this past year. It was purported or promoted as neutral because it was surveillance that covered a wide area across the city. And in fact, monitoring could even be used to monitor the conduct of police officers. But what we actually saw when pulling together the maps of the flight patterns of these aerial surveillance planes that they primarily circled and hovered above Black communities. And take, for example, the use of electronic ankle monitors. Now that a number of communities have raised the alarm and rang the bell with respect to the wide-ranging effects disproportionately against people in communities of color, the response has been, well, let's use cell phone apps to surveil and monitor individuals instead of, for example, focusing on the things that we know that matter, stable housing, living wages, health, and other social supports. So with the unwavering faith that technology can address these really large social issues, when race and surveillance concerns are raised, we get these techno-legal solutions fixed on purporting or fixing purported small bugs and hiccups in the technology. So surveillance technology today presents additional barriers and hurdles, I argue, to addressing the ways that racialized surveillance manifests in policing and corrections. And I think understanding the histories of racialized surveillance is important for informing the way that we think about Fourth Amendment protection, jurisprudence, and advocacy, and other related criminal legal policy in several ways. And I'll mention them quickly before I end. So first is with respect to these distinctions that we draw under Fourth Amendment and public and private actors and spaces. Essential to the Fourth Amendment, we note, and my co-panelists have mentioned already, essential to that jurisprudence are the distinctions that we make between government and private action in public and private locations. The Fourth Amendment only provides protections against surveillance by state actors with few exceptions. However, those limiting distinctions often hold little value for legal protection against racialized surveillance. For example, during the 19th century, both free Blacks and those enslaved who escaped, the concern was not just with state surveillance, in fact, or state actors. In fact, often the most harmful, egregious forms of surveillance came from white private citizens. Indeed, similar dangers present today when white persons end up calling law enforcement when Black individuals are engaged in normal everyday activity like bird watching or studying or entering into apartment building or barbecuing. Although those surveillance measures are not state action, they draw upon and are fortified by the threat of outright state force through police intervention, which often acts to legitimize and enforce racialized beliefs of criminality and unworthiness. Also important to note is the blurring between government and private action. New surveillance technologies developed and run by private companies make it difficult to find a line between government and private action. For example, if a private citizen receives a free or discounted Ring doorbell camera from law enforcement in exchange for allowing police officers direct access to stored or live feeds, a policy we have here in Baltimore, does that amount to state surveillance? I would ask, would it make a difference to the Black teenager who is flagged to police officers by private owner for looking suspicious? Even more, Fourth Amendment protections are limited to spaces where there is a reasonable expectation of privacy. Thus, generally, the more public the location, the less there is an expectation of privacy. This distinction, I argue, rests in part on a privileged conception of privacy, one much or often divorced from the realities of freedom and safety, which also impact our understanding of privacy. Public locations are just as much deleterious spaces as are private spaces with racialized surveillance practices. During the 19th century in Baltimore and Philadelphia, both free and enslaved Black people were subjected and watched by law enforcement and white citizens, and then subjected to great violence when racial tensions flared. Freedom and safety often relied on avoiding and being protected against that watchful eye. I also note, I think it's important for understanding the histories of racialized surveillance here, the collective versus the individual frame, and also how we think about data privacy. So histories of racialized surveillance also reveal the need to understand and respond to harms beyond the individualistic frame. Oftentimes, to be able to effectively address these problems, we have to think about the harms as collective harms, as community harms. And much of the law and policy governing surveillance prioritizes elevating and demonstrating individual harm and impacts. Also, we also rely too heavily on data privacy as a framework. I think data justice is an apt framework as well. It's a strong framework for shaping law and policy as it highlights and foregrounds the place of data-driven surveillance and related big data decision-making and governance in conceptions of social justice. I think another important note I'll make here with respect to racialized surveillance and new technologies is the persistence of racialized surveillance practices showing that one-off bans on specific technologies may not be enough, particularly when the use and deployment of these technologies are based on economic profit driving private companies developing these technologies. This drive is led in large part by these interests that people say are the data is the new oil or gold. I argue that perhaps we should say that data is the new cotton, as elements of racial capitalism can be seen in the emergence of surveillance capitalism. And those stories and legacies of surveillance, of racialized surveillance that follow the efforts to monitor and watch particularly Black communities have always shown that those surveillance practices are connected to buttressing systems of economic exploitation of Black bodies. And I'll end just here on this note. I think these are all distinct law and policy challenges that surveillance technologies present to addressing racialized surveillance. And I'll connect that back to Ellison's work. What people need is to be seen, not watched or surveilled. And what we've seen very starkly over the past year is that Black lives and other marginalized people's lives will continue not to matter for far too many individually, but more importantly, they will continue to be examples of Black life not mattering institutionally, as long as those Black lives are monitored instead of being seen. Thank you.
Well, thank you all for those incredibly incisive and provocative remarks to get us going. What I'd like to do now is turn to the Q&A portion of our panel. I will start off asking our panelists a series of questions, and then after a short time, we will open it up for audience Q&A. Audience members, I want to remind you that if you have questions you'd like for us to consider, please type them into the Q&A function rather than the chat function. So to start off, as all of you have commented on the boundaries, possibilities, and limitations of the Fourth Amendment, Jamil in particular, you made the case that the Fourth Amendment seems sufficient, that the foundations of the Fourth Amendment are still alive enough to cover the problems that we are facing. So Jennifer and Chaz, I'd like to ask for your opinion. Do you agree with Jamil that that is in fact the case, that the Fourth Amendment is sufficient to protect the privacy rights of citizens, or would you instead advocate for state legislatures and the federal legislature to design and adopt a digital Bill of Rights as a supplement? Or alternatively, would you suggest that encryption technologies will do enough to bolster the privacy rights of citizens?
Well, I would say that the Fourth Amendment is not enough, which is why we continually advocate for more protections at the state and federal level. So before the Supreme Court decided Carpenter, we already had Cal-ECPA in California that protected location privacy and provided a warrant for location data, all different types of location data, not just historical cell site location information. It's hard because then you get a patchwork of state laws that you have different protections in different states. But it is beneficial to do that because it takes like I said, 10 years or more for these cases to get up to, or these issues to get up to the Supreme Court. So I think we need both. I think we need not interpretations of the Fourth Amendment that rise to the challenges of surveillance of today. And I think we need state and federal laws. In terms of encryption, I don't think that encryption is ever going to fully protect our privacy, because there are always ways to break encryption. And because, as we've seen through a fantastic report that Upturn just published, in the case of cell phone searches, the majority of cell phone searches that police departments are doing today are not even subject to a warrant. They're because somebody consented. The police convinced somebody to turn over the data on their phone. So I think we need to address that problem before we even get to the encryption question, just in domestic law enforcement issues.
I'll weigh in and say, I think in thinking about that question, whether or not the Fourth Amendment is enough, I think about that in multiple ways. So what first is just looking at the text and the requirement of the Fourth Amendment as it stands. Is that enough to provide the sort of protections that we need in terms of these advancing surveillance technologies and having constitutional standard based upon reasonableness? I would argue yes, if in fact we adopt the frameworks and the policies understanding of what is reasonable. I bring a critical perspective to the law, and I think where we see that Fourth Amendment is not enough is in the Fourth Amendment jurisprudence. Fourth Amendment jurisprudence has not gone far enough, and I think at any given moment in time, our law is a reflection of political power and relationships. So when it comes to determining and interpreting the Fourth Amendment and who should be protected and how we should protect it, I think that's where the Fourth Amendment is not enough. Additionally, and that is only in the context of state government surveillance and action. I certainly think that the Fourth Amendment is not enough with respect to private surveillance, which I have been harping over again and again in my comments. I think because it's particularly dangerous and damaging in terms of racialized surveillance practices, as we saw this past year with George Floyd protests, where law enforcement was working with private companies like Twitter and other third parties to be able to pull location data for individuals who are exercising their constitutional rights and making claims for racial justice. So certainly in the context of private surveillance that falls into the hands of, information falls into the hands of state, I think we need something more, something along the lines of a digital bill of rights.
So in this digital age, do you see a role for state constitutions and state Supreme Courts to augment what we're seeing on the federal constitutional level? So Jamil, I will start with you, because you had articulated that you believe the Fourth Amendment itself is still robust enough. Do you see a role for the states to get involved, to do more to protect their own citizens?
Yeah, look, absolutely. I mean, I think we've always thought about, since our founding, as the states as sort of innovators, right, and incubators for experimentation and the like. And so, if states find a need or a desire to more expansively protect the rights of their citizens, right, they certainly have the ability to do that and go well beyond where the federal Constitution or the federal legislature, where Congress has gone. And I think Jennifer's right to point to some of those examples. The challenge, as Jennifer has rightly pointed out, is that this can lead to a patchwork of state laws, across the country, and may lead to different outcomes in different states. We've generally thought that that's fine, because then you can vote with your feet and you can go to the state where you find the more protection or the less protection, whatever it is you're looking for. But as Chaz has rightly pointed out, sometimes your economic situation, your social situation can make it harder to migrate between states. And it may be very well that the states that you live in or the localities that you live in have laws and policies and procedures that are aimed at certain specific minorities, whether racial minorities or otherwise. And that can be problematic, because at the end of the day, the state legislatures are operating largely on a majoritarian principle, right? If we're talking about stuff that's developed by the state legislature or enacted through state constitutional amendments, whether through popular vote or or representative democracy in these states. And so, and you've seen how that's played out sometimes in places like California, where you've had Prop 187, Prop 209, right? You've seen how majoritarian principles can lead to challenges in the protection of racial and other minorities in states, even states that tend to be more favorable on sort of policies at in the sort of the representative democracy context. And so, I think that this is a challenging question, but I think that as a general matter, if you're looking for a way to assess how to make policies that are more protective and evaluate their impact on law enforcement and the like, and find that right balance, states seem like a good place to try the experimentation in the first instance, and then figure out what that means for the federal level. I'd rather, if I had to pick, I'd rather legislatures and elected representatives and make these rules rather than courts sort of trying to figure out what the right answer is. Right? The Fourth Amendment, should be scoped according to its text and the history. And then if we want to add on additional protections, whether at the federal or the state level, we ought to let the legislatures do that.
Can I say one thing on this? So it's interesting in terms of this question of, do state constitutions offer more protection? And it's something that actually factors into my work every day. There are lots of situations where we will look out there and do a survey of states and say which states have looked at their Fourth Amendment equivalent as coextensive with the federal Fourth Amendment. And then we won't try and pursue lawsuits in those states, because there may be some other states that have found greater protections in their Fourth Amendment. Or we'll look at things in the context of privacy protections that aren't in the criminal justice system. So for example, in California, we have a constitutional right to privacy. But where that constitutional right to privacy butts up against our Fourth Amendment equivalent, the Fourth Amendment equivalent is the one that the court looks to, and the Fourth Amendment equivalent is interpreted exactly the same as the federal Fourth Amendment. So it really, as a practitioner that has access to state courts across the country, this is something that really factors into my decision making and where to get involved in a case.
So I also wanted to pick up on one of the points that Chaz raised in his commentary, and that was the public-private location, which has long been a foundational concept in Fourth Amendment jurisprudence. Jennifer and Jamil, do you agree with Chaz that that distinction has become outdated, that we need to update the Fourth Amendment to cover watching people in private locations, in public locations as well as in private locations?
Well, I think in a lot of ways, I mean, Carpenter has achieved that through, court action or interpretation of the Fourth Amendment in large part, right? I mean, the court has determined that at least at the large scale where there's a significant scope, and we can debate whether Carpenter was significant or not, but at least in cases where there's a significant scope of surveillance of locational information, and again, Carpenter's limited to its specific facts, but it seems like at least the theory behind it can be extended. And frankly, even if you look at some of the dissenting opinions, like Justice Gorsuch's opinion in which was framed as a dissent, but I think there's actually a lot there for folks like Jennifer and in their litigation at Gorsuch dissent. I don't actually think that Justice Sotomayor had to go with the coalition of She-Built. I think that there was a way to find another path there if you read it carefully. But I think that the trend is certainly in that direction to expand the scope of Fourth Amendment surveillance. Now, to be fair, in Carpenter, that dealt with government surveillance of locations in public as well as in private. I think Chaz's point is both that, but also the point about private enabled surveillance, right? So surveillance by private entities, private companies, not just private locations and public locations, but private entities. And I think that's a very interesting and challenging situation. We haven't generally thought about the Constitution and its amendments as checks on that type of behavior as a general matter. As a general matter, we've left that to the legislatures, to Congress and the state legislatures to create laws around that, the right to Financial Privacy Act, the right to and other federal privacy statutes and state statutes. There's been talk of the GDPR, obviously in Europe, and there's CCPA in California, considerations of a federal privacy law in the state legislature. I think that in my view, it's going to be a challenge. It may not be the right approach to look at amending the Constitution or modifying the Constitution around those issues, but I think there's certainly a lot of room to consider this when it comes to federal and state legislation.
Jennifer, would you like to weigh in on that point?
Well, so I think on that point, I think we see this play out, this sort of challenge of the Fourth Amendment not applying to private surveillance. We see this play out in location data. So Carpenter established a protection for a Fourth Amendment warrant requirement for location data, and we could debate how broad or how narrow that is. But what Carpenter didn't touch on is location data that's being gathered by private companies. So now we have a situation where the apps on your phone are tracking your location pretty regularly, pretty much every app. And it's very easy to just click through the terms of service, not realizing that they're tracking this. That location data is shared with third parties and data aggregators, and then anybody can purchase that aggregated data that can be re-identified and used to track an individual. And those purchasers include other data aggregators. They include insurance companies and credit bureaus, but they also include governments. They include federal law enforcement and state and local law enforcement. And Carpenter says nothing about that. And it's challenging to know how to apply the Fourth Amendment to that kind of data where there's an argument. I wouldn't make this argument, but other people have made the argument that you've consented to that sharing that data. But certainly there's a chain of private companies in there that have done something with the data before it gets to the federal government, and the federal government or the state or local is purchasing it on the open market just like anybody else. So I think that sort of shows the limitations of even a case that is arguably directly on point like Carpenter.
Well, thank you. And now I want to build off a point that has come through all of your presentations so far. I found myself thinking as you were all giving your opening remarks, do we need a different Fourth Amendment for counterterrorism investigations and cyber attacks by foreign nationals? That is there something different about the terrorism and attack by outsiders scenario that makes our Fourth Amendment protections weaker than they should be, or too strong, or too strong? And that is, they are holding back our law enforcement agencies from doing the work they need to do to actually protect American citizens from foreign threats. So Chaz, I actually want to start with you on this one, because there could certainly be racialized implications of that, to the extent counter-terrorists often get, or terrorists get coded as deriving from Muslim countries, thereby impacting citizens of color in the United States who might be seen as being affiliated with them, but not necessarily, because we now have seen there's a narrative about threats from East Asia, Southeast Asia, the former Soviet bloc, and so forth.
Yes, I would agree. And then, you don't even have to go as far as, Muslim or international persons or connections. You can just look at some of the things that we've seen in recent history with the labeling of Black identity extremists as terrorists within the country. And then we, juxtapose that to what happened this past month at the Capitol. It raises some interesting questions. So I mean, to wrestle with this idea of whether or not we need, a different Fourth Amendment standard or cases or outcomes or policy, I think maybe is a secondary question to the ways in which, or sort of investigating and understanding the ways in which we think about who is a terrorist, who is deemed as a potential threat, who is signified as someone that must be watched. And I think a lot of these assumptions are driving the way in which cases are interpreted. These assumptions, as we've seen, are driving the way in which law enforcement approaches responding to what is deemed as national security threats and the like. So I think we need to investigate sort of the larger frameworks which is driving the way that we interpret law and execute law and develop law, as well as sort of thinking about changing the language to speak directly to terrorism.
Jamil, would you like to weigh in on that? Should we have a different kind of Fourth Amendment in the counterterrorism or cyber attack context?
Yeah, I mean, having worked in the counterterrorism arena in the government for the Justice Department, and then on Capitol Hill at the House Intelligence Committee, I actually think you might be surprised by my view, which is I actually think the Fourth Amendment has served us pretty well when it comes to counterterrorism surveillance. I think that in large part we've been able to do what we need to do in terms of targeting foreigners located overseas and foreign intelligence threats emanating from overseas under our general understanding of the Fourth Amendment that it doesn't apply to foreigners located overseas and doesn't generally apply, frankly, the warrant requirement generally doesn't apply to foreign intelligence threats, right? That understanding of the law has been around since the 1970s in the Keith case, a case involving a domestic terrorism issue, but that's in a footnote essentially stated the Supreme Court's view, but without deciding, to be explicit, that the Fourth Amendment, at least its warrant requirement, the reasonable requirement does still apply, but the Fourth Amendment's warrant requirement doesn't apply to foreign intelligence surveillance. And we've had decades of case law since then, and an entire statute, the Foreign Intelligence Surveillance Act, built around that understanding. So under that understanding of the Constitution, I actually think that the Fourth Amendment served us well. Now, if there were a change in understanding, the Supreme Court were to take up a case, as I'm guessing Jennifer might advocate for, and I think EF has advocated for in the past, that would explicitly decide that Keith was either wrongly decided or didn't decide the question, which it didn't decide the question, and that in fact the warrant requirement may apply to certain types of foreign intelligence surveillance. Then I think we're in a very interesting scenario, right? And then I think we have to think about what that means for our ability to collect foreign intelligence against both terrorist threats, but also spies and the like, right? Today we operate in a world in which the warrant requirement doesn't apply, reasonableness applies, at least in the United States, and foreigners located overseas have no rights under our Constitution to any to be defended by the Fourth Amendment. I think that's as it should be.
Jennifer, would you like to weigh in?
Yeah, I mean, I think I agree to a certain extent with both Jamil and Chaz on this. I think that if you create a different standard, there's a trickle-down effect to that. So I think that terrorism and child pornography both make really bad case law on the Fourth Amendment because they're both just these terrible, heinous situations. But the problem is that if courts can't look past the facts of those cases or those situations, they could create bad law that then gets trickled down to the domestic situation. It gets trickled down to crimes that aren't heinous, but those standards already exist. So I definitely worry about what we're seeing even in the last few weeks, this talk of domestic terrorism. There's a reason why we look at, national security and foreign governments being a part of national security. And we don't look at domestic terrorism as somehow different and distinct from our criminal justice system as a whole. And I think that if we do, then it's very easy to label anybody as a domestic terrorist. And in fact, we have done that in the past. We have done that for many, many different kinds of political protesters. We've done that for communities, as Chaz talked about. So that's my real concern with a different standard.
Yeah, can I jump in on that one, Kay? I think Jennifer makes a really important point here, which is, there's been a lot of talk since Insurrection Day that we should have this domestic terrorism statute, and we ought to be able to use surveillance methodologies and national security surveillance methodologies potentially to target white supremacists and the like, and the people that were involved in the insurrection at the Capitol. And as heinous as the events of January 6th were and that rebellion that took place, and as heinous as the acts of the president were and calling for that, which I do believe he called for it, and ought to be held accountable for that, as well as the members of Congress who were involved in it and called for it and have defended it since then, including Marjorie Taylor Greene and Lauren Boebert, Andy Biggs, Paul Gosar, all of them. And there are procedures in our Constitution for dealing with people who engage in insurrection, even elected officials who engage in insurrection against the country. But look, it's a very dangerous place, as Jennifer points out, right? It's a place that has been utilized by the government in the past, right? Just as recently as the 1960s to surveil Martin Luther King, Joan Baez, the Black Panthers. We have seen the mistakes made by treating domestic terrorism, whatever you want to call it, right? It might be, it's white supremacists today. It might be Antifa. It might be Black Lives Matter tomorrow, right? It's very hard to judge where that line is going to be drawn. And I think we have to be very careful when we start talking about creating domestic terrorism statutes and about creating domestic surveillance authorities that might utilize the aura of national security surveillance to engage in the surveillance of potentially protected and even not protected activities in the domestic realm. I think it becomes very, very dangerous. I think it's a very clear line we ought to draw, and we've learned the lessons of that in the past.
I
think that's separate. I just say very quickly, I think that's separate and apart from actually, calling a spade, right? I think in Canada, they declared the Proud Boys as a terrorist organization, if I recall seeing that headline correctly. But I think that's a separate conversation between in relation to what happened at the Capitol, being able to understand and claim and speak of, which President Biden has done, surprisingly, about white supremacy and its threat to national security in the country.
Yeah, so one last thing on that, because I think there's just so much to say about what happened on January 6th. I think what we've seen in the weeks since then is that the government doesn't need a special law to find these people. This is a perfect example of when you post your entire activities online, it's pretty easy to, to find who was there. You don't need to do some secret location tracking. You can just look on Twitter. So I think it's we don't even need to apply face recognition in this context. We don't need, a lot of times these situations are used as justification for these crazy surveillance technologies. But here, this is a perfect example of why we can just use some basic police work to locate the people who were involved in that event.
Yeah, here's what I worry about on Chaz's point, right? And I think this is where it gets really interesting, right? So, look, I hate the Proud Boys. I think they're terrible. I think we should find out what they're all doing and if they're engaged in illegal activity, put them in jail, right? But here's the problem, right? So Canada calls the Proud Boys terrorists, right? Donald Trump called Antifa terrorists, right? Who, I'm sure if he thought he could get away with it, he would have called Black Lives Matter protesters terrorists, right? I mean, it becomes a very dangerous situation, right? When you start talking about when these are Americans, they have First Amendment rights. Again, that First Amendment only stops somewhere, right? Stops at the point of incitement, but it's pretty broad up to there, right? I mean, we know about the Nazi Skokie march case, right? And look, I don't want Nazis marching around my town, right, in Skokie, but you got to ask yourself, when you start going down the road of saying, okay, well, we got a domestic terrorism statute, we can call the Proud Boys terrorists, so we can prosecute them using national security surveillance methods and the like. What happens when it gets to Antifa, Black Lives Matter? Where's that line? And how do we avoid the problems we saw just in the 60s with MLK and Joan Baez and all these people? I worry a lot about that. In the current moment, I am as appalled and as upset and as angry as anybody about what happened at the Capitol. And I think the outrageous behavior of our leaders in Congress and folks in the Senate is appalling in responding to this, and not nearly enough. But domestic terrorism statutes, and I mean, to me, that's just a road to go down that will be used to use our national security tools to oppress minority populations of all kinds when it comes to their protected rights.
So to draw on the conversation that you all have
Sorry,
started,
could I just clarify my point? Just a few seconds to Jamil. My point wasn't about sort of labeling domestic terrorists or any groups. I mentioned what happened in Canada as something I saw. My point was, and this is something that we have to do as a country, as individuals that that claim that we live in a democracy, that we value freedom, liberty, the things that I espoused in my comments. We have to be able to call out white supremacy when we see it and understand the threats that it has historically and moving forward. That's why I said I began my comments by saying this is separate and apart from conversations about labeling domestic terrorism or counterterrorism.
Yeah, I apologize. I agree with you 100%. And we have to call out systemic racism and frankly, our failure as a nation to uphold the values that were espoused in our original Constitution, the Declaration of Liberty and the Declaration of Independence. We have not lived up to those values, and the events of last summer are proof of that. And we have a long way to go as a nation. I agree with you 100% on that, Chaz.
So I know that we all tend to live more in the Fourth Amendment space than the First Amendment space, but the discussion about Twitter, for example, and the actions that Twitter has taken recently in response to the insurrection on January 6th has led to a lot of First Amendment conversations. Here, as we're in Fourth Amendment land, and we think about what does it mean for Twitter to give over information to the government? Does that mean that Twitter is engaged now in a partnership such that its behavior should be thought of as state action and so forth? But can Twitter be both? How can Twitter both helpfully participate in identifying the people who are involved in the Capitol insurrection, and also then how can we have some standards about when law enforcement is wrongfully using what they find on Twitter, or Twitter's willingness to give over information in support of less high-profile prosecutions? How do we hold the line for private companies who have access to so much public information that would be incredibly helpful, private information that would be incredibly helpful to public law enforcement in high-profile cases, but also in less important, less weighty prosecutions in our nation?
So I think there's actually two things wrapped up in that question. The first is, can Twitter provide information to the government? Maybe three things. A subset of that is, are they a state actor then? And then the second thing is, how do we address law enforcement access to this type of data independent of Twitter turning it over? So in the first part of that, Twitter is a private actor, so they can do whatever they want. There is nothing that in the law that prevents Twitter from turning this kind of information over to the government if they want to. And I think that's something that we all need to think about in terms of how we advocate our legislatures to pass laws that might better protect our privacy from private companies. Because Twitter can do that, and pretty much any company that we share our data with, which is every company today, can do that if it wants to, and that doesn't make it a state actor, because the government is not going to most of these companies and saying, we need you to record these people's activity. The company is making its own decision about what it wants to share with the government. Now, the harder question, I think, is what are the checks on law enforcement misusing information that's posted publicly or semi-privately online? And that's a hard question. If you're posting something on Facebook in a private group that has 500 people in it, it's difficult to say what law enforcement, what the Fourth Amendment prevents law enforcement doing in that context. I would say that law enforcement should get a warrant to get access to that, but it really depends. We have seen that law enforcement will create a fake persona and join these kinds of groups, and law enforcement, of course, has been able to do that out in the real world for forever. And that also shows, I think, to your sort of the overarching point of the intersection between the Fourth Amendment and the First Amendment, and how government surveillance has the potential to chill speech. Because if we think that the government can join these groups or can record our information, the data that we're sharing, the information that we're sharing about us online, the intimate information that Danielle talked about earlier, I think that really does have the tendency to chill speech, and it makes us not willing to share these intimate pieces of information about ourselves. And we suffer as individuals and as communities and as society in that situation.
Yeah, I don't think that's right. We've had the misplaced trust doctrine, right? The idea that law enforcement can engage in undercover activities for 200 years, right? Nobody's ever thought that the First Amendment was hampered because the government can go into a terrorist group or a gang or a mafia organization and either co-opt somebody, right, and get them to give up information, right, get them to share information with the government because they've obtained it because somebody trusted them, or to play a part of that group and obtain the information that way, right? With some very narrow exceptions, right? In the case of infiltrating religious and other groups where there's a strong First Amendment interest, we've never thought that was a problematic situation. And the idea that somehow because you're on Facebook, I mean, you're putting up to 500 people, that's on you. If it turns out there's a government stool pigeon, well, sorry, too bad, right? Same thing as government's a law enforcement officer. We've never, ever, ever thought that ought to be the rule under the Fourth Amendment or by statute, right? That ought to be the rule. So, I mean, it's an interesting point. I mean, we should debate it, right? Certainly. I mean, I think it's an interesting question. I just don't think that's right. I'm interested though in Chaz's thoughts on this because there is a long history, right, of infiltration of organizations being focused around issues of race and minority groups, whether race or religious minority groups, and frankly political minority groups also. So I'm interested in if Chaz has a view on whether that plays a role in what we ought to do about it.
I will let Jennifer respond to the point you made in response to hers if she wanted to before I weighed in.
Yeah, sure. Well, I love that you said that's wrong, but you only talked about the part that I said at the very end, which
right. I just meant that last part. I just meant that. I didn't mean the whole thing. I just meant that tail end. I'm sorry. I apologize. I should be clear.
Yeah, and like I said, I think it's challenging. I think what I look at though is, in the decades of cases from the past that you talk about, 200 years, we didn't communicate in the way that we do today. We didn't find other people who are doing similar things in the way that we do today. And I think about in the past, what are the situations where we've had social change, and that social change would not have been possible if we had the kind of government surveillance that is possible today. So for example, I mean, you could look at slavery, you could go back that far, but you could also go to women's suffrage. Women had to break a lot of laws before we got to the point where women had the right to vote. You could look at gay rights. In many states, I'd probably say all of them, sodomy was illegal. And that was used to target people. And if we had the government surveillance that was possible today, tracking people through chat rooms, tracking through people through messages with other people, we might not have had this kind of massive social change. So that's my concern. And I hear you that we have 200 years of law or experience on this, but we didn't used to communicate the way that we do today. And I don't think that we should have to go back to a situation where we are trying to meet people in dark alleys or private rooms, like in the physical world, to find other people like us. I think that that's important, and we need to find a way to protect that.
I'll just add to the initial two areas of inquiry that I think Jennifer identified astutely. I think she mentioned that we should be, in response to the question, first, we need to think about what private entities like Twitter can do. And then secondly, in the instance where data gathering that's happening by the private entity makes its way into the hands of state, federal, local law enforcement, what sort of regulation should we have with that information? And so I think this question with respect to Fourth Amendment and First Amendment, they're so closely linked in a lot of ways. I mean, if we think about the language of the Fourth Amendment itself, I'm teaching criminal procedure now, and I talk to my students over and over again about the language, and to be protected against unreasonable searches and seizures. Well, why did the original framers of the Fourth Amendment and the Constitution think that that was something that we needed, right? They were worried about what had happened before the formulation of the country, right? So being subjected to searches by the British monarchy and coming in and having them have access to political organizing and critical political organizing of the monarchy and religious expression and those sorts of things. So when we think about the information that is being used and gathered from private entities, they're weighing heavily in these same areas of political association and gathering. So when you can have a private company take location data, provide that to state law enforcement, and then it's being used in a way to respond to and repress ultimately movements for racial justice, that is a terrifying reality. That is something that I think we need to be thinking about, and it's connected to First Amendment protections as well, of freedom and association and speech and the like. So, the questions of, whether in attempting to regulate private companies, whether it comes through, framework or sort of taking the values of the First Amendment, Fourth Amendment, it doesn't really matter. I think at the heart of it, there needs to be some weighing in and some regulation of what private companies are doing. And on the back end, I think Jamil had mentioned or highlighted a point that I was making with respect to what the government is doing with that private gathering of data. And a lot of this data now, we talk about metadata. These aren't FBI informants sitting in on the meeting. This is data that the average person could not gain access to. And that is the reason why these private entities are selling this data, because it can't be accessed in the same way.
All right, well, I am now going to turn our metaphorical podium over to our audience members. They have submitted a number of questions, so and that are now appearing to me in the chat. So forgive me, it's going to sound like I'm reading the questions off the chat, so I make sure that I am not paraphrasing. I don't lose anything from the question that has been asked. So here's the first one. Many people have said that we need X, Y, or Z law or policy change to better protect our right to privacy from government and private actors, including discriminatory monitoring and surveillance. Yet law, at least in the positivist sense, is by its very nature a creature of government with those same prejudices and concerns. Given this reality, do you think that a legal solution by statute or constitutional amendment is necessary, sufficient, or even possible to solve the problem? Or is this an area where norms rather than law should take the first step?
I think it has to be sort of all of those things. And I'll give you an example. So I've said that we litigate in the courts, we push for legislation. We also have some other folks on staff at EFF who work to really push privacy enhancing technologies. We also have folks who work out in the policy space. One of our projects that we're not doing this year, but we did for many years, was a project called Who Has Your Back? And what we did is we rated tech companies on how well they protected your privacy. And one of the things that we encouraged tech companies to do was to produce an annual report on the kinds of surveillance requests they were getting and whether they were pushing back. And just that fact of these companies getting a gold star or not getting a gold star encouraged them to put out transparency reports. And now we see most of the major companies are putting out transparency reports regularly. And that has encouraged them to be more willing to push back on government surveillance when they get a subpoena from a local law enforcement agency. They know that they're going to have to report on that, and so they're more willing to push back and say, hey, give us something more narrow or get a warrant or whatever it is. So I think that's a good example of norms supporting legislation. And then I can take those transparency reports and use some of the facts that are in those transparency reports and put them in my amicus briefs and say, look, Google got 20,000 warrants for real-time surveillance last year. What does that mean? Or Facebook is getting X number of warrants that turn over every piece of information on somebody's social media site, including their friends and their photos and everything else. And so we need better protections for that. So that would be my answer to that question.
So Jennifer, can I ask you as a follow-up, do you think then that means that it's not just norms, but there's a market effect that consumers who are unhappy with how their own tech companies are handling these issues will vote with their wallets and go somewhere else? Or are we so monopolized by Facebook and Google at this point that there really is no other choice?
Yeah, I think it's a it's a bigger issue, and perhaps the next panel, the antitrust panel, will talk about this and whether we do have meaningful choice. I mean, for me, I use DuckDuckGo for all of my searches when I possibly can, but I think for most people, they just default to whatever the the search engine is on the computer that they have or the device they have. So there are sometimes options for choices, but frequently we're sort of governed by the big handful of technology companies that keep buying out all of their rivals.
Chaz or Jamil, do you want to weigh in on the question about whether the law should follow or the norms really have a role here?
Sure. I think, I'll say first, I think the sort of, I think of, when I heard the question, when I think of norms versus law, I get the distinction and dichotomy that is being drawn. But to me, I immediately think of, chicken versus the egg, who came first sort of distinction as well, because, norms can, have impact, shape law and policy, but at the same time, law and policy can impact, express, and shape norms as well. And hey, I'm a critical legal theorist. I mean, I am deeply skeptical of what the law can do and accomplish. And certainly, part of my mission is in my scholarship is to highlight in the ways in which additional biases and politics and socio-political realities are impacting the way that we interpret and execute the law, certainly. But I am not keen on legal abandonment, I guess, sort of say. I think the law is deeply influential in everything that we do, and certainly in this area of surveillance. I don't think it's something that we can sort of leave alone and say, hey, in this silo, we need to work on, changing the way that people think or the way that people move or the way that people understand. I think, as Jennifer started out with, I think all of these things need to be happening simultaneously for us to begin seeing some of the changes and transformations that we deem necessary.
Yeah, and I think the main point to make is I'm not sure that I think that Chaz is right, that I'm not sure the distinction between norms and law is sort of the right one, because the reality is that both norms and laws are inherently majoritarian, right? I mean, norms are set because everyone sort of agrees on what they ought to be, right? And sort of the majority agrees that's what we're going to do. We're going to go forward. They may actually be more majoritarian than laws, because you don't just need a 51% majority. You need sort of general agreement to create a norm, right? And so this idea that somehow norms will evolve faster or be better and more protective than laws would be, I'm not sure that's right. But I do think the really important thing is that fundamentally what is anti-majoritarian is our Constitution and the first 10 amendments of the Constitution. Those are designed as bulwarks against the majoritarian rule, against the popular will of the people as expressed through Congress and the like, right? Congress shall make no law, right? The right of the people to be free from unreasonable searches and seizures, right? These are provisions put in place by our framers, with the exception of change through the constitutional amendment process, right, are designed to be anti-majoritarian and to protect the rights of minorities, and whether they're political or other minorities. And so, in my view, that's sort of the place to look, is the Constitution, the first 10 amendments, not to sort of norms. I think norms are actually in a lot of ways worse than sort of majority legislation.
I would say one last thing on that, and this is to agree with both Jamil and Chaz about norms being potentially problematic. You look at the reasonable expectation of privacy test, and it's very easy to look at that from a normative approach and just say, well, objectively, we should not have privacy in anything because we share our data with everybody. And that has the potential to undermine the Fourth Amendment completely if we were to take that approach. So I do worry about that kind of a race to the bottom with norms.
All right, well, moving on to the next question. This one is about facial recognition technology. It has been argued that facial recognition technology allows for more efficient law enforcement investigations. There was a recent California statute that prohibited the use of this technology by police officers. Given the racial and gender inequities of facial recognition technology, is there a growing need for more legislatures to regulate the use of this technology by law enforcement?
Yes, we have advocated for a ban on face recognition, the use of face recognition technology by law enforcement. Just to clarify, in California, we do have a statute that placed a moratorium on law enforcement use of face recognition on mobile technology, so your cell phone or your police body cam. And then at a local level in places like San Francisco and Oakland, we also have a ban on law enforcement use of face recognition. So we are pushing for that for the reasons that were listed in the question. It's inherently problematic, and not just because it's inaccurate, which is huge, but also because it has the potential to create just a complete surveillance state.
I would like to just say that I think that question was asked by one of my criminal procedure students. So thank you for being here. Just before I came onto this panel, I taught my Crim Pro class. So students are staying on and signing up for more. That's always a good sign. So I'll just piggyback off of what Jennifer's noted, which I think is important. We should be passing legislation to deal with these issues. But I think we need to be doing more than just sort of responding to the technologies as they come. I think by the time we get around to passing legislation to ban some of these technologies in a meaningful way, there's another new development in technology that we're having to wrestle with that has questionable outcomes and impacts on communities that are disproportionately subjected to the use of those practices. So I think in addition to sort of responding, we need some overarching regulation, some overarching guide. One of the things that is being piloted now in Maryland, and I think has been done in a couple of other states, is racial equity sort of analysis for criminal law-related legislation. So looking at legislation that is being passed in the state and sort of analyzing the racial equity impacts, and sort of getting ahead of some of these laws and policies that are enabling these forms of surveillance technologies that take place before they actually even roll out would be great.
Chaz, before you leave, could you say just a couple of words about how the technology works and how it has been shown that it has racialized and gendered effects?
So facial recognition technology is a software that is, in very layman terms, used through cameras. It focuses on points along the face, and it matches, with other faces and profiles within, a connected database. And one of the things that, researchers across the country, there's a film out now called Coded Bias, with the work of Joy Bolowini out of MIT, which sort of hones in on some of the racial disparities that she noted in the use of facial recognition technology. And those disparities and failures in the technology arise from just simply those who are creating and developing the technology and just not being familiar with certain faces and certain features, and who are they testing these technologies on. However, I think it's a double-edged sword when we talk about the technology not being good enough. When I first started hearing stories about facial recognition technology not being good along racial lines, as the criminal defense public defender in me said, good. Said I won't have to deal with that evidence. I could easily dismiss that evidence in court. So why even make the claim there? But in doing more research and talking to those who are or thinking about race and technologies issues and are studying this deeply, I began to see why it's problematic, and why we need to not only focus on the flaws in these technologies because of the logics behind them, right? The logic is, that we can, with these technologies, we can ensure safety, that we can ensure security. But what we see is these flaws that even when, eventually, if there is adjustments made and we can say facial recognition technology works across races and ages to a certain, level of effectiveness, it still raises questions about how and why and when we're using these technologies. And I think it's important, there to sort of wrestle with that as well. What is undergirding the use of these technologies? And that has led to the banning of them, not just, the flaws in the technology, but sort of digging under and are these necessary? And can this technology meet these larger social ills or issues that we are identifying?
So it's beyond the risk that it might lead to wrongful conviction. It's that as a technology, it is inappropriate. Even if it were effective, it's inappropriate to use.
Inappropriate, and also, there are just large question marks that are still left with a number of these technologies that are rolling out now. Most of the surveillance technologies, as they continue to develop, they are pulling and sorting and storing massive amounts of data. What does it mean to have, big warehouses of this deep biometric data, right? We already know that the, federal government has access to large face databases, but what does it mean when, local law departments and that information is filtered down? Having that information, how can it be used? We may not even understand the way that technology is developing, the way that, that sort of data, that biometric data can be used down the road. I mean, one of the areas that I that I have been researching and I think about a lot is the rolling out of facial recognition in schools, right? And a number of schools are deploying facial recognition technology, and technology that is supposed to be able to tell whether a student is upset, whether a student is holding a gun when they're walking into the building, right? So what's going to happen with that data, and will it contribute to sort of sorting that we see taking place in schools, in the criminal justice system, in the health care system, and the like in years to come? So a number of questions as well.
Thank you. All right, so Jamil, do you want to weigh in before we wrap up?
Yeah, thanks. I know we're out of time, so I'll make it very quick. Look, I mean, I'm not sure I actually agree with Jennifer and Chaz on this one. At the end of the day, I actually agree with them on the point that if there are biases in these algorithms, we have to root those out. But once we're at the point where, as Chaz says, we believe that we can get a pretty fair accounting in those algorithms, I actually think this is this is like standard police work, right? We have a lineup, we compare pictures of people to other people, right? I mean, this is how we identified, to Jennifer's point, how we identified the people at the Capitol riots, right? I mean, you want to be able to do this, right? The idea that we should just rely on no, but I mean, to your point was we were able to identify a lot of them and prosecute them, right? One of the ways we did that, in fact, is through facial recognition. And the point I'm trying to make, though, is this is standard police work, right? The idea that we shouldn't use modern technology to do standard police work more rapidly and more effectively, it actually, if we can get to the point of confidence, and again, there are reasons to think we might not be able to, and there are reasons to think there might be racial biases and the like, and gender biases, we should address those. But once we're at the point we can address those, to throw away technology because it allows you to do things rapidly and more effectively is crazy.
Well, I'm not sure if that is the right place to end. I have a feeling that Chaz and Jennifer probably could weigh in further, but we are unfortunately out of time. I want to thank our panelists so much for what has been a very exciting discussion. Thank you all for being virtually with us at Emory this afternoon. We do have one more panel this afternoon that will be addressing antitrust and technology. I hope that everybody is willing to stick around before moving into whatever virtual happy hour space you will all be moving into. But Jennifer, Chaz, and Jamil, you have been inspirational. Your backgrounds are incredible. Thank you so much. We feel so fortunate to have you with us this afternoon.